Judge Caroline Tesche Arkin is the Circuit Court Judge for the 13th Judicial Circuit of Florida. Assignments are Probate Risk Protection, Civil Division K, Juvenile Dependency, Felony, Juvenile Delinquency, Domestic Relations, Family Law Divisions. She was elected in 2008, re-elected 2014 and 2020. Judge Tesche Arkin has presided in nearly every court division since her election to the bench. She has a known reputation for having solid legal acumen, patience, and professionalism in her dealing with the bar and litigants. She has managed her courtrooms with dignity and efficiency and is known for her common sense and friendly approach to the bar and other members of the judiciary. She enjoys helping her colleagues at the courthouse and has been a driving force in numerous bench and bar activities, often with optimism and creativity. She is a strong leader and mentor through mentorship activities with the Hillsborough Association of Women Lawyers, Tampa Bay Inns of Court, and Stetson's Law School. She has presented judicial education sessions to the Florida Conference of Circuit Judges, National Conference of Juvenile Court Judges, and was a guest keynote speaker for the Massachusetts Judiciary in 2019 for her innovative work in child welfare field.
Good morning. I am Judge Caroline Tesche Arkin, and I'm a circuit court judge in the 13th Judicial Circuit in Tampa, Florida. And I just want to say that it's a great honor to be able to provide some comments to you for the Paralegal Association of Florida 2023 annual seminar. So thank you for letting me share some observations and touch in with you as you are learning your subjects during the conference and kind of thinking about the perspectives of a judge who very well might be presiding over the matters that you're working on for your firms and for your attorneys. So in thinking about what to talk about today, I wanted to say that so much of what we ultimately have to consider in our courtrooms regarding the work of paralegals gets down to how the attorneys represent themselves and present themselves and how prepared they are and how skilled they are at their craft, and also how good they are in terms of their reputation for professionalism and their ability to be ethical in their work in the courts and on behalf of their clients. So in thinking about paralegals and professional folks that help attorneys, right? So much of what we need to sort of just underscore for you has to do with what we see the attorneys do in the court. There is a connection between you and your law firms and your lawyers that is very, very noticeable at times. And your role in administering justice and in really providing the kind of work that's necessary for cases to be tried, resolved, and heard by the judges really is important. It's important work. And so I want to thank you for taking on the job. And I want to thank you for educating yourselves in this conference. And I want to touch on some ethics questions that come up and also give you a little bit of guidance from my perspective. Before we break into the materials, I want to give you a little bit of my background so you'll know a little bit about at least where I come from in terms of the courtroom and working with paraprofessionals and also paralegals. So I was elected to the bench in 2009, and I have been an attorney, a Florida attorney, since 1998, and that's a long time. I started off my work as a prosecuting attorney in Miami. I had the great pleasure of working for the Honorable Janet Reno in Miami. She was the top prosecutor, state court prosecutor there, the state attorney. And I learned very quickly about the importance of support staff in the state attorney's office as we managed our hundreds and hundreds of cases, sometimes all in one day, in the very busy courts of South Florida in the 1980s. I ended up working in the narcotics organized crime division. I tried really big cases involving lots of kilos of cocaine, robbery cases, murder cases, and ultimately left Miami and worked with the federal government up in the Northeast on narcotics cases. And I did some moving around, but I ultimately decided I wanted to come back to a warmer climate. Living in the Northeast was a little bit cold in the winters. So I came to Florida and I worked actually in the Florida Keys with a small law firm. And I think that's where I had my first real experience with paralegal support staff in a small firm that I worked for in Monroe County, doing some real estate cases and condominium law. And I got very, very close to our primary paralegal there, who just showed me about the breadth and depth of the work and service that she provided for our firm. And we are still friends to this day. 30 years later, we keep in contact. And boy, she kept our office running. She was great. Her name was Cheryl. I just loved her. I mean, she just was able to do such good work and capable work for our law firm and our clients. She was on top of every single file. She knew what needed to be filed with the court, bankruptcy court, and also in the courts that were dealing with our real estate cases. Just awesome. And I really developed a great respect for the daily work of a good paralegal who's really holding your law firm together. She was great. And ultimately, after a bit of time down in the Florida Keys, I kind of missed my own trial practice in the courtroom. I received an opportunity to be a kind of senior trial lawyer in the public defender's office up in Tampa for Julianne Holt. And I came to Tampa. I left South Florida, came to Tampa. And this really has been my home here in the 13th Judicial Circuit since the early 90s. And I worked there in the public defender's office trying really big felony cases. And I ultimately set up my own successful law practice as a criminal defense attorney. I also did contract law cases. And I had the chance to also try some cases involving bankruptcy and a little bit of civil litigation. But I too relied on excellent paralegals to help me with my law firm, and ultimately concluded that part of my career with a successful run for circuit court judge in 2009. So I've been on the bench since. And I've rotated through pretty much every division at the courthouse, starting with family law, moving into the juvenile delinquency courtroom and circuit, and moved over to the felony division. And I ultimately transferred to the family, the division that deals with dependency and termination of parental rights cases, to circuit civil for about 4 years. And then my current placement in the probate and guardianship division. So I've seen pretty much a little bit of everything at the courthouse. And I've had the opportunity to be involved in, maybe not directly, but indirectly knowing about the work of paralegals and support professionals through every one of those division assignments. And I have a great deal of respect for the work that you do. And I know that without your work and commitment to your law firms and your sole practitioners, if you're helping out in that way, the tremendous work that falls on your shoulders and the responsibility that is also there is something that the courts, that I certainly respect, and my other colleagues respect. So it's hard work and it's important work. So let me just tell you a couple things as we dive into the topic a bit for today. The first is that I'm going to give you some tips and secrets about the courthouse and about judges and what we really think and what we really look at when we're dealing with our cases. First of all, I want to talk to you about a topic that is often not really discussed, but it's kind of true. And that is, it is true. It's about the volume of cases that judges have to handle. In the circuit civil division, judges are carrying close to 15 to 1800 cases on the average per division, per judge. And each one of those cases, some of the cases are relatively straightforward. They may be negotiated and settled pretty quickly. They may just obviously be going to trial and on a trial track. But some of the cases involve very complicated motions for summary judgment or really big discovery disputes, expert witnesses. It can be any type of case that can end up requiring a lot of time that the court has to spend in litigation, going through volumes of evidence or data or depositions. There can be a whole lot of work on just, 10% of those 1,500 cases. So we have to think not only about the cases that we have in front of us, but the overall volume of our caseloads. We often find ourselves running tight on time in hearings, or we find that we don't have enough time on our dockets to actually hear cases in the manner that your attorneys might want us to hear, because it's time is a very precious commodity for the judges. And we sometimes find that we don't have enough time, or we don't have sufficient time to actually dive into the cases in the way that you might hope for or expect, I guess, even because we just have such high volume. You take that and combine that with the amount of time that it takes to try a case to a jury trial. That's just a full production. I mean, we have to bring in citizens and swear them in and go through the process of making them comfortable so that they can listen to the evidence in a case. Meanwhile, the attorneys are going to, and having to pull together their witnesses, and they're working just endless hours. For those of you that support litigation, you know what I'm talking about. Endless hours getting ready for trial. It can be just a very, very long and time-consuming process to try cases. And when we're in trial, pretty much, your attorney is out of pocket and the judge is out of pocket. And every other case that might want some attention is not going to get any attention until the case is over. And now, if you have a lot of trials that are set sequentially, one after the other, judges just get tired, and we don't necessarily have the ability to get back to the other cases that are making up our docket and need attention. So I want to tell you there are a lot of pressures on, particularly in the civil division, pressures on the court to deal with the volume. For those of you that are supporting attorneys that work on county civil cases, those numbers are 20,000 cases. And sometimes that litigation is there's just so many cases, at least in our circuit here in Hillsborough, in Tampa, which is a really big circuit. Other circuits may not have those kinds of pressures, but I can tell you the pressure of time, and that was my first topic here, the pressure of time on the court is a very real pressure, and it really affects the way we are able to do our work. And the pressures that we have in trying to manage the cases with the time that we have. So what's the first point? As a paralegal or as a legal support professional, understanding that the court, even on its best day, is faced with a lot of time pressures coming at it from a lot of other cases, not just yours. It really informs the need for you to be as efficient as possible with the ways that you communicate with the court. In other words, if your job is to work with a judicial assistant to set up a hearing or to get a special hearing, or you're needing to provide information to the court, really thinking about being efficient with your communications is a good idea. So efficiency in the way you communicate with the court is very helpful. It's better by and large for you to send requests through email to the judicial assistant for help in setting up hearings, or if there's most courthouses have an automatic scheduling system, sort of using that process, being sure to read the court's preferences for communication so that you know what your particular judge is going to need or is going to appreciate for purposes of communication, and trying to be pretty precise in the way you communicate your request to the court. One of the things that sort of goes against that is when the paralegals or the secretaries for the attorneys end up sending like very complex, lengthy emails to the judicial assistant or to the court. Those are actually disfavored because A, they take a lot of time to read, but also they may contain ex parte communications, right? So be very precise and careful in not overstating your request or trying to put in any information in the request that might be an attempt to sway the court. Can't do that, okay? So just be precise and cautious with the way you spend the court's time on communications. Same thing goes for sending materials to the court. Most important thing you can do is read the court's preference page to find out what this particular judge appreciates. So we are able to continue to manage our case loads as efficiently as possible. So that's important. That's the first step there, is good communications with the court, understanding that we're really overloaded. We have very big caseloads, and a lot of times our judicial assistants are also under the gun trying to produce and trying to keep things moving. So we always like to do that. Now, you also have to know that the court on its own may be setting hearings that are important for you to communicate with your attorney about, and that you're going to have some work to do. So understanding the expectations of the court and being able to work with your attorneys on that is very much a part of that smooth transmission of information that will really help us all be better at what we do. All right, so the next thing I want to talk to you about is the concept of professionalism and ethics, and how do they relate to what you do, and how do you help your attorneys be the best attorneys that they can be and need to be under the rules of court in Florida, under both the professionalism rules and the ethics rules. So I want to tell you just as a general overview, Florida, and really most other states, we have codes of ethics. And our Florida codes really require that, attorneys maintain themselves with honor, integrity, and fair play, that they're not to distort facts or opinion. They're not to stand silent when they need to advise the court of something that is important, germane, and relevant to the case. That really, the attorneys are to seek just and speedy resolutions of the trial or the dispute, and really to abstain from abusive and disrespectful behavior. Finally, another point that I want to make is for attorneys appearing in my courtrooms and courtrooms throughout the state, the idea that your word is your bond. In other words, you present yourself as a professional. I intend to rely on that because your word is your bond. It is such an important idea that the attorneys that appear in front of the courts are honest and trustworthy, and that what they say really can be taken to the bank. That's an important thing. So I'm going to kind of talk about those in those principles, and maybe dive in a little bit about how professional paralegals and support professionals can help and actually facilitate those important requirements here in Florida courts that your attorneys have to abide by. All right, on honor, integrity, and fair play. Okay. You know, in my courtroom, since I've been doing this quite some time, I can really tell when an attorney is trying to kind of kick the other side when they're down, right? By by being unfair, by making disparaging remarks, or by trying to really disparage them by their words, um, and or by their actions in the courtroom. But I got to tell you that some of this starts back in the office, back at the law firm, where, wow, we really want to get this guy. We really, really want to expose them in a way that the court, we really want to show the court how bad this guy is, right? That's not acceptable. I want everyone to be honorable and to treat each other with honor and integrity. Back in the office, when you're back in the office and coming up with your strategic plans for a court hearing or for a responsive pleading or whatever, really important to keep in mind that the best win is a clean win. And so you start with what you are advising your attorneys about, what to do, by providing honorable and honest information to your attorneys. I can tell you that the next part of this really is it's related to this, and you're not to distort facts or opinions, and your attorneys are not to do that, right? So if your obligation or your assignment is to obtain information or research cases for your attorneys in their preparation for court or for pleadings, or to obtain expert opinions or to do that research, it is very important that your research be conducted with honor and integrity, and that you not distort or change facts or opinions to fit with the narrative, okay, of what might be better for you. It's never that way. It's never that case. The best information and the best opinion and the best facts are truthful facts. So even though it may not be comfortable to share what you have found with your counsel, your attorney, that may go against the plan, you have to share it. You have to share the negative case that you found that goes against the principle, or the opinion that you found from another expert, or even the fact that has been divulged to you through a client that really changes the way your attorney is going to present their case or has to present their case to meet their ethical obligations. So to be clear on this, part of your duty as a skilled and really good paralegal is to present honestly to your attorneys evidence or information that is negative. It's the bad news. If you have to do a good news, bad news sandwich, that's okay. But you need to make sure that the bad news about the truth is disclosed to your attorney so they can figure out how best to present it to the court. All right. Super important. Now, I will tell you that there are occasions when attorneys will come in to court and they'll say, wow, my paralegal blew it, Judge, or my secretary blew it and didn't do this and didn't do that. And, they'll fall on the sword. They fall on the sword. Ultimately, it's their sword to fall on, not yours. But every now and then, there is a mistake that is made. There is a mistake that is made by a paraprofessional, and the court hears about it. I can tell you that most courts are going to be forgiving if the truth of the mistake is shared quickly and appropriately with the court and the other side. Because guess what? We're all human. Certainly, my judicial assistant has made a mistake or two. I have made many mistakes. And even the best paralegals will miss something or have a circumstance that arises in their life that we have to be fair and listen to, okay? So, every now and then an attorney comes in and says, you know what, our office dropped the ball. Well, it's really your attorney's ball to drop. Okay. So you can't just blame it on the paralegal or the office manager or the secretary, the legal secretary, or the runner or whatever. But generally speaking, the attorney takes responsibility, but sometimes they'll tell us what happened with the paperwork that wasn't filed or that got missed or what have you. And let's just hope that the judges are fulfilling their duty by not being overhanded or too heavy-handed in the way they deal with those admissions, right? We need to work together to keep the system flowing. And part of that is by having a human response when it's required. So, in my own practice as a judge, I really give people the opportunity to tell me the truth without being fearful that they're going to get in trouble, because it's just not right. I want us all to get through the process of managing these cases for these clients, for the people that we're serving, in the best manner. And hey, there's going to be winners and there will be losers, but at least the process will be fair. And a fair process means fairly addressing mistakes when they are made. So take a breath, tell your attorney if there was a mistake that you made so they can figure out how best to present it to the court. It may be something that if you make a mistake, your attorney has a very good relationship with the opposing side, and he'll or she'll put a call in and they'll have a communication, and the issue won't even necessarily have to go to the court. It can be fixed. Most everything has a reasonable resolution, a reasonable way to fix. So take a breath, just communicate honestly and openly with any mistakes that you make, and your attorney, your counsel should be able to figure out a way to get that provided to the court. We see this a lot in questions of scheduling, where, well, Judge, we just weren't able to get the thing scheduled. My paralegal forgot to schedule it, or we didn't put it on the docket. Okay, we just need to keep the cases moving. So it doesn't have to be a really big brouhaha. We'll just keep it moving. So let me talk to you a little bit about the abstaining from abusive and disrespectful behavior requirement. Now this is a hard one, because attorneys end up with reputations that they develop, and sometimes they take a real long time to develop. It takes a long time, forever, to develop a really great reputation. It doesn't take very long for it to fall apart by disrespectful or abusive behavior in a courtroom or to opposing counsel. And sometimes the reasons why attorneys have these issues is because they have personal problems that they have been dealing with, like a family emergency, or they're dealing with an illness, or something's happening in their life. We have to be aware of the pressures of this profession, both on attorneys and also on paralegal staff and everybody that works with us in the legal system. It's not an easy place to work, and sometimes the pressures become overwhelming when other things are happening in our lives, and it can happen to judges too. So, kind of understanding that, again, that human approach, that taking breaks and being careful with your own self-care. Those are things that can help to reduce situations where you start having reputational issues because you're coming unraveled to the opposing side or the court in court. But I can tell you that the abusive and disrespectful behavior cases that make their way to the bar and sometimes end up in sanctions against attorneys, and ultimately in very serious cases disbarment, that those are cases where there is sometimes a root in the office where the strategy is to just play extreme disrespectful hardball with the opposing side in emails and in phone calls, and it's just a hot practice that is negative. If you're in that kind of work environment, think about whether you really want to be there, or if there may be better places for your talent, because I'm telling you, your work environment does matter. Having attorneys that are level-headed and good-hearted and smart and well-respected and good to you, those are the things that are really hallmarks of a good work environment. But if you are in the position of beginning a process of communicating negatively to the opposing side, to the paralegals or support staff on the opposing side, or there is a culture in your practice of being non-professional in communications, email, phone communication, texts. We see examples of these things going between law firms that don't even generally make their way to the court, but we hear about them, that are just, it's wrong. It's not the way to be a good professional, a good paralegal, a good paraprofessional. You don't want to be the person that is fighting that way on behalf of your firm or at the behest of your firm, because it really speaks to sort of what the overall point of view is, which is the point of view that gets attorneys in trouble and ultimately, can be very, very bad and toxic for a number of people, including the paralegal staff. So making sure that you have in your own practice a system of just very professional communications with the opposing side and with the opposing side's staff and with the court, being that professional that, when I see an email sent from a paralegal or a paraprofessional to my judicial assistant, I'm like, wow, he or she really is classy. This is just the really right way of doing this. That's where your reputation builds. And quite frankly, that's where your career ends up becoming more and more robust and attractive to your firm, to your current employer. You end up really doing the best work as a professional paralegal. I want to go to a sort of final topic here, which is interesting to tell you that I know paralegals and your association has requirements. I'm sort of speaking from the judicial requirements of lawyers and sort of how it transcends or translates to the paralegals. But I want to share with you the oath of office. This is the actual oath of office that your attorney took in order to be sworn into the Florida bar. Okay, it says, I do solemnly swear I will support the Constitution of the United States and the Constitution of the State of Florida. I will maintain the respect due to the courts of justice and judicial officers. I will not counsel or maintain any suit or proceedings which shall appear to me to be unjust, nor any defense except such as I believe to be honestly debatable under the law of the land. I will employ for the purpose of maintaining the causes confided to me such means only as are consistent with truth and honor, and will never seek to mislead the judge or jury by any artifice or false statement of fact or law. I will maintain the confidence and preserve inviolate the secrets of my clients, and will accept no compensation in connection with their business except from them or with their knowledge and approval. To opposing parties and their counsel, I pledge fairness, integrity, and civility, not only in court, but also in all written and oral communications. I will abstain from all offensive personality and advance no fact prejudicial to the honor or reputation of any party or witness, unless required by the justice of the cause with which I am charged. I will never reject, from any consideration personal to myself, the cause of the defenseless or oppressed, or delay anyone's cause for lucre or malice, so help me God. All right. Wow. That's quite a mouthful. And that's what every attorney has to swear to the court, to me or another judge that swears them in, they're going to do in order to be members in good standing of the bar. So your attorneys have taken that oath. Your attorneys have guaranteed with their oath that they know that that is what is required of them, and they promise that they will do that. How does all that translate to you? Well, we've talked a lot about in this conversation communication and the importance of integrity and honesty. But each one of these points really raises something to think about. I'm going to shortcut it. I'm going to go through it and I'm going to tell you what I think the relevance is of each one of these statements is for a paralegal to think about. Okay. And I would urge that you, at some point, when you have a chance, go to the Florida Bar admission of oath for the attorneys and run off a copy of it. Just run it off and keep it somewhere so you can look at it every now and then, because you should know what your attorneys, your bosses have agreed to. Okay. This is the contract with us, and with all of us as citizens. All right. Support the Constitution of the United States and the Constitution of the state of Florida. Well, that's very that's self-evident. We know what that means. You're going to follow the laws. You're going to follow the laws. So guess what? As paralegals, hey, you need to know the laws, and you're learning it. And you're having, educating yourselves on that, and that's important. Clearly, we are a nation of laws, and that's the first sentence. Maintain respect due to courts of justice and judicial officers. So, hey, how that relates to you, of course, your attorneys have to be nice to the judge in the courtroom, but you need to be respectful to the judges if you have any sort of interaction with us, but also with our judicial assistants and with the court staff. It's awesome. It's just number one, be nice to them and be respectful. That's easy. I will not counsel or maintain any suit or proceedings which to me appear unjust, nor any defense, except which I believe honestly debatable under the law of the land. Well, that's mostly for your attorneys not to take cases that they think are not legally appropriate to take, that there is no law that supports their client's position, right? If you ever have a feeling that the case just doesn't feel right to you, I would suggest you talk to your attorney about it. So maybe your supervising attorney can give you their perspective on it. Your perspectives as a team member and your sense of the case is actually an important part of the equation for your firm. So if you have any doubts about the merits of the case, hey, hopefully you'll have the kind of relationship where you can talk with your counsel, your attorney about that, your managing attorney. Anyway, you cannot mislead the judge or the jury by any artifice or false statement of fact or law. Well, if you're doing legal research or if you're looking into factual research for your attorneys, it's the basis of your work that allows your supervisor to be able to present the truth of the law and the facts to the judge. So this is a pretty important one. Your attorneys have to make sure that you are doing your work properly, but you also need to make sure that you are doing your work properly and getting to the truth if you are researching legal subjects or factual subjects for your counsel. So that's important. It's sort of like you've got to have the best evidence and the best legal arguments to win, and making sure that you're dedicated to that excellence in your practice is going to really help your attorneys have the best outcomes. Okay. I will maintain the confidence and preserve the secrets of my clients. Well, obviously, confidentiality, client confidentiality, also hooks into the fiduciary duties, right, that you know a bit about. These are very important. You can't be giving information to the other side about your client or even to the court unless it's authorized, by your counsel. Those attorney-client confidences are absolutely held by you as well. So keeping in mind that that's one of the requirements. It's important. To opposing parties in their counsel, I pledge fairness, integrity, civility, not only in court, but also in all written and oral communications. I spent a fair amount of time talking about that in our presentation this morning. That's a new addition. That addition was added, I want to say something like maybe 8 years ago, because in this nature of rapid electronic communications and emails and even texting, there tends to be less formality and sometimes a little more ratcheted up communications between firms, attorneys, and their law firms. Some of the examples of the disparaging remarks and really just downright crazy things that attorneys were saying to each other got to the point where the Florida bar decided to add this new section here about written and oral communication restrictions. You can't be rude. You have to pledge fairness, integrity, and civility. That means being civilized, not throwing out adjectives and disparaging remarks or racial statements or anything that is perceived or is in fact, uncivilized. So we now have a section here that the attorneys are agreeing to. And to you, we spent a fair amount of time on that at the first part of my comments here, but it's really important that you develop very, very good, careful drafting skills in your emails to the opposing side and to the court. If you ever feel yourself ratcheted up by the other side or by the paralegals on the other side or anything that may be happening, I would strongly suggest that you take a minute before you blast off an email. I've actually talked to judges where they say a 24-hour rule, depending on how upset they are before they send the email. You don't want to hit send all, respond all. You don't want to blow confidentiality by responding to all on an email chain where your client may have been put in as a blind copy. You have to be very, very careful with your responses and actually self-regulate what you are saying so that you don't find yourself inadvertently or because you're just angry, not being civilized. Okay. And there are so many examples of that. It's just incredible what people will say to each other. Just don't do it. Don't be that person. I will abstain from all offensive personality and advance no fact prejudicial to the honor or reputation of a party or witness. That's also just part of professionalism. Your client, your counsel, your attorneys know to not do that, but it's important. We're not here to trash people. We're here to get justice on particular cases. So maintaining that diplomacy and decorum is really all the best that you can do, and it's the right thing to do. All right, and I'll never reject from any consideration personal to myself the cause of the defenseless or oppressed or delay anyone's cause for lucre or malice. That means two things. Number one, your attorneys have the obligation to take the hard cases and to do pro bono work and to really, help people that need legal counsel. On the other hand, they also have the obligation to not prolong cases for profit. Okay. And that happens sometimes in family law cases or other cases where, like, the longer the clock ticks, the more money the firm gets, but that may not really be fair or in the right interest of the client. So be really aware of that. Be aware that, every case really should have a certain shelf life. And some cases need to move faster than others. And always at the end of the day, it's the client's rights that you represent. I mean, that's where the prize is on effective and careful, conscientious representation. So my final topic here for this conversation, again, is I want to talk to you a little bit about artificial intelligence. Artificial intelligence, AI. Now, we are seeing more and more artificial intelligence pleadings and legal arguments, and the use of artificial intelligence is really just at the beginning. But I want to tell you that we're going to be seeing some safeguards that are going to be established through different rules and procedures. And I think it's going to be an area that clearly has a lot of importance in terms of the way it can be utilized for good, but improperly utilized for not so good, that it's very much worth highlighting and sort of thinking about and opening the dialogue. I just returned from a judicial conference where the question of artificial intelligence was discussed in the context of a law firm that used artificial intelligence to write a brief. But unfortunately, I mean, the arguments looked pretty good and it was pretty well written and everything. But when the judge got a copy of it, and so did the other side, they started fact checking the law and found that all of the cases that were cited to by the moving party were fake. They were not real cases. Every single case site was a made-up case site. So the attorneys that propounded this, well, they violated a number of the rules of professionalism and procedure. But each one of these cases was fake, made up by artificial intelligence with a full case site and a court, fake name, but it looked good. I mean, it looked like a real case until the attorneys in the court started looking them up and they just didn't exist. So the judge required of the moving party within 48 hours a full opinion from each one of those fake cases to be presented to the court, filed in the court file, and sent to the opposing counsel, right? Because I couldn't find these cases. Well, obviously, the moving party fell on their artificial intelligence sword and told the court, oops, these aren't real. And there were sanctions ultimately by the Florida bar. And, it was a big, horrible mess. Going back to the first point, which isn't even the most important point, boy, was that a waste of the court's time and the time of the other side. Boy, that certainly didn't get anybody any closer to resolving the dispute. Boy, that certainly didn't help people understand the real facts and legal issues of the case. And boy, was that a real solid wake-up call about artificial intelligence and how it can be extremely troublesome isn't even the word I would use, frightening, dangerous, extremely problematic for the courts. And, the attorney, and I don't know what the relationship is between the lawyer who did it and the paralegal staff or the artificial intelligence paralegal that they hired. I don't know. But very problematic. Do I think as a judge who's been on the bench for, I don't know, 20 years or so, almost 20 years, do I think that it is a bad thing all the way? No. I think artificial intelligence and using AI resources may be a potentially great resource. But we can't forget the importance of solid legal research and truthful fact-finding on the law and the facts of the cases. And that's the kind of thing that a computer can never do. Okay, these are important nuances that have to do with the skills that you're developing as paralegals that you may get some help on writing, but clearly developing the proper presentations by using real cases, real classic legal research, that's not going away anytime soon. And we're going to see some regulations coming in because courts can't have their time wasted like that. And it's not fair for the litigants. So be careful when your attorney says, hey, go get a brief by AI. Yeah, no, we got to make sure that what comes to the court is honest and has integrity. So, wow, I have enjoyed this. I want to, again, thank you so much for letting me present. Here in the 13th Judicial Circuit, if you have any questions as follow-up to this, I think there's a system whereby I can respond, and I'll be happy to do so. Caroline Tesche Arkin, Circuit Court Judge, 13th Judicial Circuit here in Tampa, Florida. And if you ever happen to be in the courthouse and you just want to come by and chat and say hello, I have an open door policy. And so you'd be happy to say hello and have a cup of coffee with you. Like to hear about how things are going for your careers. I do also teach trial advocacy with one of our local law schools. Been doing that for a number of years, and having been a trial lawyer and then presiding over a number of jury trials, one of my favorite things to do is to teach in the dynamic environment and see how folks are learning their skills and crafts. It's always exciting. So I hope you have a pleasant conversation here and ongoing session here with your training. Please let me know if I can answer any questions. And it's really been a pleasure. Thank you so much.